You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 20, How to Write the Cross-Reference to Related Applications section. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at patentingforinventors.com. That's patenting, F-O-R, inventors.com. Or you can call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are allowed to practice patent law in any state, so feel free to contact me regardless of where you live. In episodes 9 through 19, I went over all the sections that pretty much every utility patent application should have. I went through the order that I like to do it in, which are the claims, the drawings, the detailed description of the embodiments, the brief description of the drawings, the background, the brief summary of the invention, and the abstract. There are some patent application sections that not every application will have, and I'm going to cover them in this episode and the next episode. The first one you should know about is called the cross-reference to related applications. Let me tell you what this doesn't mean first. This does not mean that you find some application that's similar to yours, so you think it's related, and you write down that patent number. That's not what related means here. Related means whether this application is related to any other patent application you may have filed. So if this is the first application you're filing that has anything to do with your invention, then you don't include this section because this application isn't related to anything else that you filed. I'm probably going to do a follow-up to this topic later on because there are some different times when you might want to file a related application, and we haven't gotten to those types of applications yet, which are called continuing applications. There are different types, which are called continuation applications, continuation in part applications, and divisional applications. You could also claim priority to international and foreign applications, but it doesn't make much sense to talk about that right now because we haven't even finished how to file your first U.S. application. The one scenario that might apply to you, even if this is your first invention, is if you filed a provisional patent application. I talked about provisional patent applications in episode 8. If you filed a provisional application, then you must have in your application the cross-reference to related application section. Why is this important? For provisional applications, remember the whole purpose of a provisional is to allow yourself 12 months to file the regular or non-provisional patent application. If you file your non-provisional patent application within 12 months of the provisional, then no references in the public that came after you filed your provisional patent application can be used against you in determining whether you should get a patent in your non-provisional application. Just to recap, if you filed a provisional patent application on January 1st, 2018, and some reference came into the public on February 1st, 2018, that reference can't be used against you as long as you filed your non-provisional patent application by January 1st, 2019. But let's say you never filed a provisional patent application on January 1st, 2018, and you only filed a non-provisional patent application on January 1st, 2019. Then that February 1st, 2018 reference could be used against you because it came out before you filed your application. If you want to hear the pros and cons of provisional applications, go back and listen to episode 8. So how does the Patent Office know whether the regular, non-provisional patent application you first filed is claiming priority to the earlier filed provisional application? Well, you have to tell them, and that's what this section is for. You have to write down that the application you're filing claims priority to your provisional application. I'm going to go over the situation where you are filing a non-provisional application that wants to claim priority to a provisional application when you file for the same invention. What you need to know when you do this section is your provisional application number and the date it was filed. It's a very simple one sentence that you put in. You write, this application claims the benefit of U.S. provisional patent application number, and then you write that number in, filed, and then you write the date that the provisional application was filed on. So an example might be, this application claims the benefit of U.S. provisional patent application number 621234456, filed January 1st, 2018. And that's it. Sometimes you'll see an additional sentence that says, the entire contents of which are incorporated by reference herein. What this means is that if you happen to forget to put in anything in your non-provisional, but it was in your provisional, you are incorporating everything that was in your provisional. I'll get more into incorporating by reference in a later episode, but it's actually not necessary to put that in the cross-reference to related application section because it's understood that when you claim benefit to something, then you actually get the incorporated by reference by default. Some people also like to put in the title of the provisional patent application, so that's fine as well. There are all sorts of different rules about also putting this section in what is called the application datasheet, which I'll cover later, and what to do if you forget to claim priority at the time of filing and how to fix that, and how much time you have to fix it and how much it costs. But just do it right the first time so you don't have to deal with that mess. A few things to remember. It's possible that you have written more than one provisional application before the non-provisional, and you should claim benefit to both. Remember to also say that you're claiming benefit to a provisional application, because there are other types of applications you could claim benefit to, which I'll cover later, and you have to say the type of application when you claim benefit to an application. Another thing that you should be aware of is that just because you're claiming benefit to or priority to another application, it doesn't mean that your later filed application is safe, because as I talked about as one of the cons in the provisional application episode, you only get the benefit of that earlier date if your provisional sufficiently disclosed your invention that you later claimed. For example, there was a case about a patent for a new drill bit. The inventor filed a provisional application for the drill bit within 1 year of selling it. According to US rules, that's okay, because you have 1 year to file an application after selling it. Then they filed a non-provisional application, and one of the claims was about the bit body being at a specific angle relative to the housing. That non-provisional was filed more than 1 year after selling it, but that should be okay as long as they claim benefit to the provisional application. That's the whole point of filing a provisional and claiming benefit to it later. But what happened is that the court looked at the provisional and found that nowhere in the provisional did the inventor write about the bit body being at a specific angle to the housing. Because the provisional didn't discuss it and the non-provisional claimed priority to it, then claiming priority to the provisional was entirely useless because you can only claim benefit to things in the provisional that were disclosed in the provisional. The point is, claiming benefit to a provisional is necessary if you want the benefit of that earlier filing date, but it might not be sufficient. In order to be sufficient, you have to make sure that what you're claiming also finds support in the earlier filed application. Also, you can only claim benefit to an application that is still pending, not an already issued patent. If you filed a provisional application, that means you have to file your non-provisional that claims priority to it within 12 months, because after 12 months, it becomes abandoned and you can't claim priority to it anymore. If you filed the non-provisional within 12 months, but forgot to actually make the statement in the application where you said you were claiming benefit, there are things you can do to fix that, but it's better not to get to that stage and just claim benefit at the time of filing. As I mentioned before, this type of cross-reference to related application, where you claim benefit to a provisional application, is one of the ways where you might need to claim benefit. But there are other scenarios where you claim benefit to applications that are not provisional applications, such as continuation, international and foreign applications. But for the time being, I'm assuming you're doing your first patent application, and maybe you filed a provisional application. If you want help with drafting your patent application, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.